Hello, my name is Andrew Green, and I'm a contributing reporter for Devex based in Berlin. For months, I've been covering discussions within the World Trade Organization about steps to ensure equitable access to COVID vaccines, therapeutics, and tests. I'm really excited to be joined by an incredibly smart group of panelists today to discuss where those discussions have gotten us and what impact they've had. Before going any further, I'd really like to introduce them. I'm joined today by Nirmalya Syam, Senior Program Officer for Health, Intellectual Property, and Biodiversity Program at the South Center, Fatima Hassan, a South African human rights lawyer and social justice activist, and the founder and director of Health Justice Initiative, and the recent winner of the 2022 Calgary Peace Prize for her contribution to justice in the international struggle against global health and inequality. And also by Weinian Hu, a research fellow with CEPS, an independent Brussels based think tank where she specializes in EU China trade relations, EU Asia relations, and intellectual property. Before we move forward, I just want to set the scene a bit. It's been more than a year and a half since the South African and Indian delegations tabled a proposal at the WTO to waive intellectual property protections on COVID vaccines, treatments, and tests. Their TRIPS waiver would offer temporary access to patents, industrial designs, copyrights, and trade secrets. It has garnered significant support, with more than 100 countries coming out in support of the TRIPS waiver, but also detractors from the pharmaceutical industry and allied countries. A few months ago, a compromise agreement brokered by the United States, the EU, South Africa, and India emerged and has moved into text-based negotiations at the WTO. The draft that has been made public only discusses waiving patents on vaccines. So it's a much reduced version of the original proposal. The WTO Director General is pushing members to reach an agreement by the ministerial in less than a month. But I'm hearing reports out of Geneva this week that negotiations are not advancing very rapidly. Against that backdrop, I'm eager to discuss not just the current state of play, but the impact that the waiver proposal has had on conversations about access and the role of the WTO. And I thought I'd start with Fatima, as one of the leaders in the effort to get the TRIPS waiver adopted. I wanted to ask you about what you anticipate will happen next, and if the original waiver could be resurrected, or if the quad text is the only game in town at the moment.
Thanks, Andrew, and just such an honor to be on this panel. So I think let's just take a step back, to June 2020, when the South African government warned about the consequences of not properly dealing with intellectual property restrictions in the middle of a pandemic. Shortly thereafter, South Africa and India, as you've mentioned earlier, tabled the full waiver proposal, as we call it, which deals with all intellectual property elements on all COVID-19 technologies for the duration of the pandemic. What we've seen in the last few weeks is a text that was purported to have been agreed to by the EU, by the US, and by South Africa and India. But our governments are saying to us that that is not their text. That is not what they agreed to, and that this text actually represents the views of the WTO Secretariat. And it certainly has been presented that way in the last few weeks. It's under what's called the DG's responsibility. So we don't see it as the quad text, and we certainly don't see it as the text of what our government basically negotiated or agreed to informally, even in Geneva. And we've pushed back on our own government, indicating that they shouldn't sign that particular version of the text that's been shared by the DG, because it represents quite a fair deal. So what do we think is going to happen? Unfortunately, I think what may happen is one of two things. Either the global south will be bullied, particularly given the way in which the EU currently is handling these negotiations right now in Geneva, into agreeing to a version, and a very watered down version, of the original proposal, which only deals with vaccines, which only deals with patents, and not all of the different elements that make the waiver proposal. Alternatively, what could happen is that there will just simply be no agreement, because the global south will push back and say that this is not what they actually wanted when the original waiver proposal was advanced and basically tabled at the end of 2020.
Weinian, I wanted to move to you next. I know that you might have a bit of a different perspective on the two documents that we've been talking about so far, the TRIPS waiver proposal and the the Quad document, and I was wondering if you could discuss which you think kind of points to a better outcome, and more generally where we are at the moment.
Thank you very much for inviting me, Andrew. In my opinion, the proposal itself is not necessary at all, because what the proposal is about is to let the public good prevail over exclusive private property rights, which is intellectual property rights in times of emergency. But in the context of access to COVID-19 vaccines, that public good is already prevailed in spirit, in letter, and by international community efforts. In letter, I meant those policy flexibilities that the TRIPS has provided in terms of compulsory licensing, in terms of other instruments such as special and differentiated treatment for developing countries. And let's not forget that among all the 92 COVAX countries, 35 of them, those least developed countries, the TRIPS agreement is not even applied in those countries until 2033. On that, I really do not think it's necessary to waive the TRIPS agreement or patent protection in order to ensure equitable access to vaccines by developing countries. And in terms of international community efforts, I meant those incredible financing instruments provided by countries, provided by the IMF, and those lots of donations, and those new vaccine plants that have been building in South Africa and in Singapore. So I really do not think it's necessary to have this TRIPS waiver or patent waiver for developing countries' equitable access to vaccines.
Thanks very much for your perspective. Nirmalya, I wanted to give you a chance to respond to what we've heard from the two presenters so far about the current state of affairs.
Thank you, Andrew, for inviting the South Center to this talk. And we are in the middle of what could be a very significant moment in the history of TRIPS and in the history of WTO in terms of the outcome of this the current discussion going on. Fatima has already mentioned about how where we are from where we started, and the suboptimal text that we currently have, and the possibility of such a suboptimal text being pushed through coercive persuasion or pressure on developing countries. And our hope is that the developing countries would be able to resist that and come up with improvements to this text and have a better outcome, better decision agreed to in the WTO. But in terms of reacting to just what the previous panelist was mentioned, if you look at where we started off in 2020, we didn't have vaccines at that moment available. And if you see what action some of the developed countries have taken at that point of time, you would see that a number of countries, including Germany, Canada, they had adopted legislations allowing the use of compulsory licenses, government use authorizations for ensuring access to COVID-19 related medical countermeasures. At that point of time, we didn't know what the vaccine scenario would be like, etc. We also should keep in mind the fact that it was very evident at the very outset of this pandemic that what you needed in terms of a response was a rapid scaling up of manufacturing capacities. You needed all hands on deck and sharing of the technology. And in that context, a policy space that facilitated such scaling up of manufacturing technologies was felt necessary, and that's what drove the proponents to seek a waiver of obligations of the TRIPS agreement. And this is meant to be, this proposal was put in the spirit in which it was intended, or waivers are intended. The WTO agreement, the agreement establishing the WTO under Article 99 specifically states that waivers could be sought for special reasons under any agreement. And once those special reasons are raised by particular member states who make that proposal, the matter would be discussed in the relevant council, in this case for the TRIPS Council, which stipulates that it should be done for a period of 90 days. But as we have seen, it's been almost 1.5 years into this, and we have seen essentially a lot of filibustering, delaying concrete progress towards an outcome on this. We have, it is correct that the TRIPS agreement is not an obligation that least developed countries have to apply. They have the flexibility as LDCs not to protect pharmaceutical patents, for example. But the fact is that most of the LDCs do not have manufacturing capacity. They would essentially rely on a few countries, developed and developing, who have the manufacturing capacity in normal times to access the medicine. And you have the Doha Declaration, under which the Para-6 system was established, which we have also seen has its limitations in terms of the fact that it has been only used once. And one prominent example of the limitation of that system is that even in the face of a pandemic, only one country actually tried to see whether this system could be utilized, Bolivia. They had put in a notification of their intention to use the system. And a company in Canada had also applied for necessary administrative clearances, I believe, in terms of scheduling in the Canadian CAMR system. And the matter was stuck over there. The point, so we have seen in one example where an existing flexibility, a mechanism that was established under the Para-6 system, Article 31, which was sought to be used, it didn't really work out. COVAX has sort of come up to a bit of a scale only of late. But in the height of the pandemic, and while I say this, I should stress that the pandemic is still in operation. It hasn't finished by any means. We are seeing perhaps a fifth wave in South Africa. In that context, we have seen that the supplies have been too little, too late. And the intent was of the waiver to facilitate scaling up of production so that you do not have a situation of too little, too late. In some sense, regardless of the outcome of these negotiations, we have seen a systemic failure of the WTO to respond timely to this, to possibly the greatest public health crisis of our times. So I would stop there, and perhaps we can continue going forward. And I think Fatima could also comment on the situation in South Africa with regard to the mRNA hub, etc. My only comment is that the issue of IP is still yet to play out in the context of the mRNA hub and how it could work out. The companies involved, Moderna, for example, or Pfizer, they have not actually shared their intellectual property rights we have to see whether the pledge that Moderna has made not to enforce its patents would play out. But then if it goes on to enforce its patents, who is to stop them? They would have breached their moral obligation, perhaps, but legally they would be on the right to do so. And what you need is legal certainty. So I would stop with those comments for now. Thank you.
Thanks a lot. That's really helpful. In passing it off to Fatima, I also wanted to ask, we've seen the Quad text, or as you kind of described it, the DG's text perhaps is centered around the compulsory licensing model that Nirmalya was just saying is broken, is not working. I'm wondering if perhaps almost counterintuitively, there's an opportunity here where it's gotten so much criticism and attention that it might force a discussion about what's lacking within the current boundaries of what's available to countries when it comes to the WTO. Like, could it foster a discussion around rethinking the compulsory licensing system?
Thanks. I think it's doing something more than that, Andrew. I think it's pointing to the total irrelevance of the WTO and a set of trade rules that are not fit for purpose in a pandemic. And I say that because, we fought for the flexibilities in the TRIPS agreement through the Doha Declaration as HIV/AIDS activists. But show me how many countries have successfully and speedily been able to make use of a compulsory license against a set of very powerful vested interests in the last 25 years. Nirmalya has talked about the BioLease Johnson & Johnson Bolivia case, but currently we have Pfizer refusing also to transfer the technology and share the knowledge on Paxlovid, a very important treatment for the management of COVID in the Dominican Republic. So much so that Pfizer has claimed that their human rights are being infringed. So it is not easy, and I think that it's really an act of gaslighting for the European Union to turn around and tell countries in the global south, oh, well, just make use of the flexibilities, make use of compulsory licensing, when they know very well that often it is dragged out for years and it's almost impossible to succeed at. I mean, even legislative efforts to try and make use of generic versions of life-saving drugs or to use parallel imports, let alone compulsory licensing, basically attracted the entire global multinational pharmaceutical industry, to litigate against Nelson Mandela when he was the president of a very new democracy in our country. So we've got past experience with the fact that compulsory licensing measures are very, very difficult to basically take and implement and enforce, and voluntary licensing, or the so-called drip feed of fill and finish licenses in this pandemic in particular are basically not going to take us out of this pandemic. So often what we get told is, well, Aspen has a license and BioVac has a license from Pfizer, but if you dig deep into that, it's still about control by pharmaceutical interests. It's not the WHO deciding on the terms and conditions. It's not elected governments and sovereign nations deciding on the terms and conditions. Companies who are unelected and their CEOs and their boards, and by default their shareholders, are deciding which countries get to set up limited manufacturing facilities, where those supplies have to go to. You'll remember that last year we managed to expose a very scandalous kind of situation where vaccines were being pulled and finished in South Africa, but were being diverted to Europe for prioritization of European customers first. So there's a number of limitations with the so-called voluntary licensing model, which is obviously not working because it gives too much control to the companies that are issuing those licenses. In the case of Pfizer and Paxlovid, for example, they've excluded almost half of the world. They've excluded Brazil from the licensing conditions and terms. And similarly with the Pfizer and both, initially the J&J license in South Africa, those are only for fill and finish. So if we come to the mRNA hub, and I think that's at the heart of why we needed this waiver, because the idea was, given what I've explained to you about how difficult it is to get a compulsory license, these flexibilities are actually not working really well at all. And it all depends on who has the money and who has the power and who has the best set of lawyers that can drag out the case for years and years and years. So it doesn't allow you to respond timelessly to an urgency of a pandemic of international concern. So what we have is a situation where, without the waiver or without an immediate, sharing of technology and sharing of the knowledge and non-enforcement of IP, without any kind of conditions, without any kind of time limits, which is basically what the waiver, was seeking initially in late 2020, you have a situation where the mRNA hub has been established in South Africa. It's actually down the road from me here in Cape Town, where there has been no cooperation. No explicit cooperation from Pfizer and Moderna in the middle of a pandemic, where the WHO estimates that the new death toll is at least 15 million people in the space of 2 years, $13 trillion of economic losses within the space of 24 months. We're now entering the fifth wave in South Africa. And the devastation that has played out in the rest of the world, I think is something that, all of us should hang our heads in shame, because we had the tools. We had the ability to vaccinate the entire world timelessly at the same time quite early on in this pandemic, and we chose not to. And timing does matter. Timing in a fast-moving, fast-evolving, uncertain pandemic is critical. So when you drip feed licenses, when you drip feed supplies, when you make it difficult to issue a compulsory license or a voluntary license, and you don't engage in technology transfer with the mRNA hub, and you call it a nice to have, this is what the CEO of Moderna has actually referred to it as. He's also likened it to a fake Louis Vuitton handbag in the middle of a pandemic. Then you have a serious problem. So without the waiver of all of the different elements of IP for a temporary period during this pandemic, it's going to be very difficult for the mRNA hub to do their work. And worse is that you have a company saying we will not enforce patents, but they filed the patent in South Africa and they are refusing to withdraw them. And our government is unable to suspend them. The last time our government tried to take on pharmaceutical power, we were put on a trade watch list. So the consequences, Andrew, for trying to even take compulsory measures or trying to force companies to act in a very different way. Nirmalya calls it in a moral way. I would call it in a necessary way, an ethical way, even in a legal way. To use the very flexibilities that the TRIPS agreement gives you, you do face, a whole set of trade pressures and possible sanctions. Just my final point, Andrew, on the waiver is that when we talk about gaslighting, what we mean is that 100 countries have said what we needed in this pandemic. 65 co-sponsors of the TRIPS waiver proposal. It's quite incredulous that you have a system at the WTO where a handful of countries can actually block, what the majority actually decides. And so when we say it's not fit for purpose, I think what this entire conversation is actually showing in the current developments and engagements in Geneva is that there really isn't democratic processes that are playing out, because if there was, we would have prioritized what 100 countries or 65 member states had been asking for a very long time. Thanks.
Great. Thanks very much. Weinian, I wanted to give you the chance to respond to what we've talked about and also to speak to the quad text that's emerged, which I know you've written about, and how you see that position within the larger debate that's happening, and if you see it as a useful shift in the conversation.
Thank you very much. Now, I would like to highlight that there are conflicting evidence in terms of how useful compulsory licensing is. I mean, anyway, the argument against compulsory licensing is that the instrument is not effectively used or not widely used. But there are two main complaints against that. It's about time and it's about money. And as I said just now, the evidence supporting different arguments. For example, on this paragraph 6 application, in that case, Rwanda and Canada case, there are different reasons as to why this it took nearly 4 years to get this application done. But in any case, we should understand that compulsory licensing is not the purpose of compulsory licensing is not to issue many of them. It's to basically to provide affordable medicines for the poor. And on this, I think it is rightly said in the TRIPS waiver proposal, where the two countries says that developing countries have legal and institutional constraints when applying flexibilities. On that account, I think the EU's proposal gives the right direction, basically to clarify and simplify the compulsory licensing authorization procedure, and also to give certainty as to what is adequate remuneration. Although at that time, we have this the UNDP guidelines, and we have other guidelines, but the EU just gives more more criteria for economic remuneration. And I would like to also say that in terms of, to me, what impedes developing countries' access to vaccines It's not a technology transfer. It's not I mean, even for manufacturing, we have to see it with perspective, because basically we see it manufacturing requires a vaccine supply from 0 to billion. Of course, it takes lots of time for companies to repurpose, to scale up their manufacturing purposes. But in any case, the EU's proposal simplify and clarify, as I see it, is more for future pandemic proof. Why? Because for the time being, what needs to be done is being done and is already done. And if we read the WTO info note on what are the problems for access to vaccine, it's not about manufacturing, it's about export controls at borders. I think that on that part, it is wrong for the EU that time to erect border controls to stop vaccine exports. That is wrong, but definitely it's not a patent's fault. It's not IP's fault that developing countries' access to vaccine is being delayed.
Thank you very much. It's been a fascinating conversation and it's gone by really quickly. With the last 3 minutes, I want to give each of you 1 minute to answer the big picture question I was hoping to get to, which is what do you think the impact of this discussion has been more broadly on thinking about the WTO and the role that it plays, and also issues of access in the future? I'll start with Nirmalya, please.
Thank you. So broadly speaking, the waiver has actually galvanized global public opinion in a big way to seek a solution at the WTO for that would be fit for purpose in regard to response to a pandemic. We saw the pressure of public opinion actually drove the United States. I think it was last year at some point of time to agree to negotiate on the waiver proposal, climbing down from its strident opposition to even consider this. And then after that, we didn't have the check being written essentially on it, right? So the question going forward is, in addition to what kind of a waiver outcome document or outcome text we will have eventually, if we get there, would be to look at going forward what kind of reforms perhaps should be considered in the context of this experience. The experience tells us that when there is a global pandemic like this, it would take at least 2 years to come to even a waiver if you need a waiver. There would be idealistic debates, etc., which is something that you don't need at that point of time. And therefore, perhaps time has come to think of considering an automatic waiver in the context of future pandemics to be built into the TRIPS agreement. And there is a potential for doing this in terms of the fact that there is Article 73 of the TRIPS agreement, which provides for an automatic review after 5 years, which has never been done really, because nobody wanted to open up the Pandora's box and potentially have a TRIPS plus TRIPS version of TRIPS. But that is something that could be considered going forward. The other issue also is for us to stop and ask ourselves in terms of justice, whether if the situation had been reversed today, would EU and the US have the same positions had the shoe been on the other foot? Had we had delay in access to vaccines in Europe, and the developing world having a situation like we have currently in Geneva, you can go around anywhere without masks. It's life as it was before 2020. If you were to go back to that situation and the situation were reversed, would the developed countries make the same demands that they're making of developing countries today? Would they propose same things in the text? The answer obviously is no. And therefore it means that text currently that is being pushed through reeks of an unjust outcome. And therefore, that should ideally be avoided. Thank you.
Well, I guess we'll have to end there as we're out of time, but this was really fascinating. And I want to thank each of you for your contributions. This was a really interesting and provocative conversation. So thanks again, and I really appreciate your time.
Thank you.